Tinker versus Des Moines, 1969, by Tan, Bauer, and Thomas.
1. Background of the case. To protest the Vietnam War and support a proposal for a Christmas truce, 5 children in Des Moines, Iowa chose to wear black armbands to their school. The principals of the schools implemented a policy that would require children in school to remove the armbands. If they refused to comply, they would be suspended and sent home until they did. The 3 children in high school and junior high school were suspended on the basis of their armbands for the duration of the protest. In conjunction with the ACLU and the State Civil Liberties Union, the parents of the Tinkers challenged the action of the school board in federal district court. Its decision upholding the policy was sustained when the Eighth Circuit deadlocked in its review, which resulted in a direct appeal to the Supreme Court. This led to the two sides emerging: Tinker, which through their parents, the students sued the school district for violating the students' right of expression and sought an injunction to prevent their school district from disciplining the students, and Des Moines Independent Community School District, where the principals of the Des Moines schools created a policy that stated that any student wearing an armband would be asked to remove it, with refusal to do so resulting in suspension.
In this case, the court is being asked to decide this question. Does a prohibition against the wearing of armbands in public schools as a form of symbolic protest violate the students' freedom of speech protections guaranteed by the First Amendment?
2. The decision.
After reviewing our case, we came up with a hypothesis, and we thought that the court would rule in favor of Tinker, like in West Virginia State Board of Education versus Barnett, where the Supreme Court conceded that students had First Amendment rights. And for the actual decision, we were correct, and the court ruled in favor of Tinker in a 7-2 majority.
3. Court's reasoning. The majority opinion was delivered by Justice Abe Fortes. The court held that the armbands represented pure speech that is entirely separate from the actions or conduct of those participating in it. The court also held that the students did not lose their First Amendment rights of freedom to freedom of speech when they stepped into school property. In order to justify the suppression of speech, the school officials must be able to prove that the conduct in question would materially and substantially interfere with the operation of school. In Excerpt 1, it was emphasized that this type of symbolic act that is within the free speech clause of the First Amendment. In Excerpt 2, it is emphasized that the wearing of armbands is akin to pure speech, which would have repeatedly held is entitled to protection under the First Amendment. In Excerpt 3, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Also, during this time, the Chief Justice was Earl Warren, and in the Warren Court was based on 2 general conceptions that may have been in conflict. The first was the idea of a living constitution, a constitution that evolves according to changing values and circumstances, and the second was marked by the re-emergence of the discourse of rights as a dominant constitutional mode. During his era, many cases were passed, and this could also be a reason why Tinker was ruled in favor of in this case. 4. Similar cases.
Our first similar case we chose was Angel vs. Vitale, and the background of this case is that a New York state law required public schools to open each school day with the Pledge of Allegiance and a prayer, in which the students recognized their dependence upon God. The law allowed students not to participate if they found it objectionable, which the schools thought seemed fair. However, a parent sued on behalf of his child, arguing that the law violated the Establishment Clause of the First Amendment. This case was argued on April 3, 1962, and it was decided on June 25, 1962. For the final vote, it was a 6-1 decision for Angel. The decision held that official recitation of prayer in public schools violated the First Amendment's Establishment Clause. And how our case and this case is similar is that both cases establish limits on public schools' actions based on the First Amendment. For our second similar case, we chose Hazelwood School District versus Colmeyer. And the background of this case is that the Spectrum, which is the school-sponsored newspaper, of Hazelwood East High School was written and edited by students. And in May 1983, Robert Reynolds, who was the principal of the school, received the page's proofs for the May 13th issue. Reynolds found 2 of the articles in this issue to be inappropriate and ordered that they be deleted immediately. Kathy Kohlmeyer thought this was going against her First Amendment rights and decided to bring this case to court. This case was argued on October 13th, 1988, and it was decided on January 13th, 1988. The final decision was 5-3 for Hazelwood School District. The court held that the First Amendment did not require schools to promote particular types of student speech. The court held that schools could refuse to cooperate with speech that they found inconsistent with the shared values of a civilized social order. And how this case relates to our case is that both cases concern students' rights at schools, mainly concerning the First and 14th Amendment, which is the freedom of expression.
5. Impact. How does this case affect us today? On February 24, 1969, the court ruled in a 7-2 vote that the First Amendment applied to public schools. Justice Abe Fortas said, "School officials do not possess absolute authority over their students." Yet today, there is still a question of how much the First Amendment applies to school, mainly concerning the introduction of a dress code. A court ruled in favor of dress codes, stating they do not violate rights as long as they're consistent and fair. Standard set. The standard set was that with the court ruling, students are able to express themselves freely at school. Citing the First Amendment established that this issue is bigger and everyday citizens could relate to it, therefore it was accepted nationally. So now when we go to school, we have freedom of expression, we can wear whatever we want, we can have political statements on our shirt, and that's mainly due to Tinker versus Des Moines and the court ruling. Some examples we can see of this today are the ACLU, or the American Civil Liberties Union, has successfully defended the right of students to wear an anti-abortion armband, a pro-LGBT t-shirt, and shirts critical of political figures. Another example is the ACLU National Board of Directors Youth Affair Committee renamed its annual youth affair as the Mary Beth Tinker Youth Involvement Award. And finally, thanks to the ruling, students are able to wear statements of movements such as LGBT and Black Lives Matter. 6. How to remember this case. Don't tinker with my armband.